please your lordship, I, together with my Matthew Arsenio, together with my learned friend Cesar Montoya, appear on behalf of the appellate in this case, Mr. Charles. My learned friends, Ms. Uranus and Ms. Evans, appear on behalf of the respondent, Mr. Bennett. In particular, this case pertains to whether or not there's a duty of care under the negligence cause of action owed to a third party. Whether my client, and additionally whether my client is contributory negligent due to his impecuniosity that inhibited from obtaining his own evaluation. Senior counsel for the respondent shall deal with the first issue, and junior counsel shall deal with the second issue. At this time, would you like a factual summary?
Yes, a very brief one. That would be helpful.
Okay. In the case presented before you, it's clear that my client wanted to purchase the property for £300,000. When he made this offer, Mr. Anthony, the seller of the property, countered back with $500,000. My client was not persuaded. However, he was shown an evaluation by Mr. Anthony, conducted by Mr. Bennett, that persuaded him to pay £480,000. The evaluation was negligently conducted because once the property was purchased, the actual valuation only came out to £300,000. Thus, my client took a hit of £180,000.
Counsel, did your client have a contractual relationship with the valuer?
No.
And so on what basis should we find that without any kind of direct link, that there's a duty that's owed to your client?
There's a duty owed to my client. If you look to the Capero Industries and Dickman case, which is cited in yellow, and reported in the official law reports appeals case for 1990, starting on page 609, you will see that a three-part test has been laid out, establishing for a duty of care to be established that it has to be reasonably foreseeable, there has to be a close and direct relationship, creating a proximate relationship between the parties. And that.
But haven't you just acknowledged that there wasn't an approximate relationship?
Actually, there is a proximate relationship. If you look to, my lord, there is a proximate relationship. If you look to the case of Smith and Bush, in that case, it established that third-party liability or liability of a duty of care does extend out to a third party. In that case in particular, it established that if you turn to the green section in your case, in the binder, on page 835 of Bush and Smith, which was reported in the official law reports appeals case for 1990, it defined proximity as a relationship between two parties where the person who causes the harm should have foreseen that his carelessness might have caused the injured person harm. In this case, it's clearly relevant that, or clearly easily foreseeable that a potential buyer would rely upon an evaluation of an evaluator.
Sorry, are we talking about the foreseeability limb or the proximity limb?
Well, the foreseeability limb, we're talking about the foreseeability limb of it in this regard, but the foreseeability has to be established in order, doesn't have to be established, but it's good cause to show the approximate closeness of the relationship. Because if it's not foreseeable, then how are they going to be approximately related as well? So in that case,
so are you saying you can't have foreseeability without proximity, or that you can't have proximity without foreseeability?
You can't have proximity without foreseeability. It's easier to establish foreseeability than it is proximity. That's what I'm trying to say. Okay. In the Bush case, in the Smith and Bush case, the plaintiff paid an inspection fee to the building society. And this case is analogous to the case before us.
Counsel, did your client pay a fee for evaluation?
My lord, he did not pay a fee for the evaluation. However, besides the fee that was paid and and also the warranties in the Smith case, they're almost completely identical. If you look to my client, we shouldn't focus on the fee that was paid, but rather the detrimental reliance that he took.
But doesn't paying a fee fundamentally change the relationship between two people?
I do not believe so. I believe the fact that my client, whether you pay a small fee of $50 to get an evaluation, or whether or not you take the evaluation and detrimentally rely on it and pay 180,000 pounds more than what the property is actually worth, I think that the result is the same. And I believe that in a position of being an evaluator, that you are put in a special position where people are relying upon your knowledge of evaluating properties and your advice that you have given, and to that it creates a special relationship of sorts.
But I can sort of see how it might be foreseeable that someone might rely on your evaluation. But I can't at the moment see how there's a relationship of sufficient proximity here to justify the imposition of a duty of care. So can you address that head on and tell me on these facts why you think there's sufficient proximity?
Okay, I believe that there's sufficient proximity because if you look at the Smith case and if you look at the Harris case, which were heard together, essentially what we had a counsel and a mortgage company that hired either their evaluators to do it and handed over the evaluation over to the party, correct? In neither of these cases did they directly negotiate or get an evaluation of their own from an evaluator. So it was someone else handing them over. In this case, it's the seller who handed over the valuation the same. Thus, it still establishes a third-party liability for a duty of care, and both those cases, it was established that there was that the proximity prong of the Caparo test had been met.
So what's the limit though? Surely it can't be any third party.
Yeah, of course. If you look at the distinguishing case before us, the Caparo case establishes the bounds and limits of how far this liability for duty of care reaches. In that case, it was shown that shareholders, an account doesn't have a duty of care to shareholders, and we completely agree with this holding. If you take a company such as Google, and you can't expect that the account was going to have a duty of care for someone who owns 3 shares of that stock. However, it can't be found that they're going to, and because they're not approximately related, they're too far. That's where the bounds would be drawn. However, he would have a duty of care to someone who's a majority shareholder in that company because the proximity and the control over the company is much more closely linked.
Because I'm still struggling with the notion that in the 2 cases you cited, the payment was made by the plaintiff for the valuation. And so the person providing the valuation for the building society, in essence, the building society is just a middle person for the plaintiff. We don't have those facts here, and I'm really struggling to see the connection.
My lord, I understand your question. What I was trying to establish before was the fact that they are a middle person in between, but in this case, the seller, Mr. Anthony, is acting as that middle person because he's reaching out to the evaluator and obtaining the independent evaluation.
But on his own behalf, he wants it for himself. He doesn't want it for the buyer.
Yes, he wants it for himself, correct. However, his intent is irrelevant to this case because it goes to the liability of the evaluator and whether or not an evaluator in his job description would be liable for a third party, and I believe that a potential buyer would be liable for that. As I say in the Caparo case, where we established the bounds, correct? I used the example of Google, where you'd be liable for a majority shareholder, right? Because the direct proximity is more closely linked. In this case, this isn't someone far removed. This isn't like a tenant, for example. This is someone who is trying to purchase the home. This is essentially someone who if you're going to use Google as an analogy, someone who's trying to purchase an entire company. Thank you for your time. If there's any more questions, I quickly address.
I'm happy.
Your time's up, Councillor.
Thank you, my lords.
May it please your lordships, as stated by my learned friend, I shall respond to the first ground of appeal as to the duty of care that is not owed by the respondent to the appellant. In proceeding to the substance of appeal, I have 3 submissions. First, that the respondent owed no duty of care because it was not foreseeable that his valuation would be used by Anthony to sell the house. Second, and most important, there was no proximity, as the respondent could not reasonably foresee that his valuation would be relied upon by the appellant. And third, that the imposition of duty of care would not be just and fair, as there was neither foreseeability nor proximity.
So you mentioned that the second prong was more important. Does that mean you're conceding the first one, that there really was foreseeability?
No, my lord, there was no foreseeability.
It's not foreseeable that somebody who evaluates a property would then have someone who's purchasing the property rely on that valuation? That's not foreseeable?
My lord, what I'm trying to say is that it was not foreseeable that the respondent's valuation would be used by Anthony to sell the house.
What would it be used for?
It was just for his own use, just to know the value of the house. Our client had no idea that the house was going to be sold. He was not told any of the facts. He was just simply asked for a valuation.
You might not have had actual knowledge, but it's enough, isn't it, to have what we call inferred knowledge. So, you know, you could reasonably have foreseen that this might be used in some way, relied on in some way that might cause someone loss. Isn't that right?
Yes, my lady, that is right. That is correct. However, again, he could not reasonably foresee that it would be specifically used to be sold, for the house to be sold. He could not reasonably foresee that the valuation was for that specific use.
Why? I mean, there are a number of reasons why you might have a valuation of a house done, but isn't the main one because you're about to sell it?
My lady, there are, like you said, many reasons why one could have a valuation. It could be just for, you know, his own use, to know what the house is worth, the house can be an investment in itself, so he might not necessarily want to sell the house right here, right now, and especially since the house was in such a high price area, it was not foreseeable that my client's valuation would be the sole valuation that was to be used by the seller. The foreseeability, as stated in Capero, and as my learned friend Matthew Arsenio stated, as stated in Capero Industries against Dickman and others, reported in the official law report appeal cases for 1990 at pages 617 through 618, sections H and A, there are 3 factors that determine negligence: foreseeability, proximity, and the fairness and reasonableness of the imposition of duty of care. The foreseeability ingredient is discussed in the Smith against Eric Bush decision reported in the official law reports appeal cases for 1990 at pages 843, sections E through F, found under the blue tab. It was not foreseeable that the respondent's valuation was to be used by the appellant. The Smith case greatly discussed the idea of the high end versus the modest price of the house.
So where's the line? What is an expensive home versus a home that's not expensive?
An expensive home versus an expensive home would be the line would be drawn by the area. It is pretty common to know that Kensington is a high-priced area, and for someone to get one valuation and solely rely on that valuation is, again, not foreseeable. This goes into the proximity ingredient, and basically the respondent knew that his valuation, as stated by the Smith case, the respondent should know that his valuation would be relied upon and communicated to the appellant. In our case, the respondent had no idea that his valuation would be the single valuation, especially because it is a high-end area. and it is also greatly discussed in the merit against that case at pages 1184, paragraph C. When one buys a modest house, he will most certainly rely on evaluation, but when one buys a high-priced house, he will not rely on that single valuation. He would go for another second opinion.
But he would rely on the first opinion. He might rely on multiple opinions, so might very well rely on this single opinion.
Yes, my lord, but that goes exactly to your point where you said there must be a contractual relationship between the valuer and the buyer. There was no such relationship in our case. The respondent did the valuation for the seller, not for the buyer. He, again, goes back to foreseeability, goes back to reliance, which then goes back to the idea of fairness and reasonableness of the duty of care, hence why it would be not fair or reasonable to impose this duty of care.
Isn't it perfectly reasonable to impose a duty which requires a professional to do their job properly, which this would? Why should he be able to conduct his business in a way where repercussions don't flow from his actions?
Yes, my lord. You're absolutely right. However, again, this imposition of duty would be fair and reasonable if there was a contractual relationship between the third party, which is our client.
You don't need a contractual relationship. You can have a duty imposed as against an individual and a third party without a contract.
Then I guess this goes back to the whole idea that there is no proximity.
So you concede effectively your case stands or falls on proximity.
Yes, my lord.
Okay.
Proximity and foreseeability. I still believe, yeah, proximity and foreseeability. Because again, it was not foreseeable that our client's report would be the sole report relied upon by the buyer, by Charles.
But if it would be a report relied on, then isn't it foreseeable from the valuer's perspective that the purchaser of the property would rely on it?
My Lord Schultz, this goes back to the point that my learned junior will discuss, which deals with contributory negligence. It is our understanding that the appellant was contributory negligent and that he should have gone out and sought out a second opinion on the house, especially since it is a high-end house. It is in a high-end area, and he should not be relying on one single report when buying this house. He should have multiple opinions. He should have multiple valuers viewing the house, and he should have, which was again greatly discussed in both the Smith case and the Merritt case. In both those cases, the court found that if this was a high-end house, then there would be contributory negligence, and the respondents would have the appellants would have the duty to seek a second opinion.
What if he had got more opinions and then he disregarded those opinions because he didn't think they were very good or something, and nonetheless relied on this one?
Then now he would still be contributory negligent because there would be multiple opinions stating that the first opinion was wrong and that it would basically be his own fault for buying this house because he has multiple opinions stating that this house has structural damage and that is not worth £500,000 or £480,000, but £300,000.
But what if, I suppose my point is, what if the other opinions are also wrong? They're also negligent. It seems a little perverse that the situation changes simply because other negligent opinions have been produced as well. I mean, the fact is, as has been stated, he's relying on that value nonetheless, isn't he? Regardless of how many he's had done.
Yes, my lady. Then I guess the facts of the case would be different. We're dealing with these current facts where he only has one opinion. If he had multiple opinions, then we can see that our client would be negligent, that our client, along with all the other valuers, would be negligent in producing this report, which was essentially a lie. However, in this case, the responsibility falls on the appellant and not on a respondent. because again, this was a high-end house in a high-priced area, and he is,
Counsel,
He's
part of
basically-
it would require even more of a professional valuation, important opinion that others would rely on. Why should we put the onus on a layperson and not on the professional?
would you like me to answer that question?
Yeah, after that.
Okay. Basically, again, this goes back to the idea that there was no contractual relationship between our client and my learned friend's client. He did this valuation for Anthony. Had he done this valuation for Charles, for the appellant, then we could say that there was proximity, we could say that there was foreseeability, and we could say that it would be just and fair to impose this liability on him. However, in this case, because there was no contractual relationship, he had no idea that his report would be used to sell the house. He could have just done this report for, investment purposes or purposes of, simply knowing how much the house was worth, and, everyone pretty much gets their house valued, and not everyone necessarily wants to sell the house. So in this case, again, it would be up to the appellant to get second or third opinions, because he's the one wishing to buy the house. It's in his own interest to get the best value. So why would one simply rely on one valuation that was not even done for him, and that he did not pay a fee for?
Thank you.
Thank you.
For the appellant, and I shall be dealing with the second ground of appeal. With respect to the claim of contributory negligence, Mr. Charles had no contributory negligence due to his impecuniosity. First, my lords, we have conceded that, as in the case of owners of dredger, Leisbach, and owners of steamship Edison, where a ship caused damage to another ship, the court held that, in general, it will not take into account a claimant's impecuniosity when assessing his damages because they are considered too remote from the consequences of the respondent's acts. However, this is not an established general rule that should be applied when the facts suggest that the appellant behaved in a way that was reasonable and that the damages could be foreseeable. If I may refer, my lords, to the case of Alcoa Minerals of Jamaica, Inc. and Herbert Broderick, in page 371, it states that a plaintiff who is under a duty to mitigate is not obliged, in order to reduce the damages, to do that which he cannot afford to do, particularly where, as here, the plaintiff's financial stringency, so far as it was relevant at all, arose as a matter of common sense.
Didn't it arise because he spent too much money on a house?
Much obliged, my lord. Yes, he was going through a moment where he was spending, he was making an offer for a house, but he relied greatly on the valuation which was provided to him, and he was not in a situation where he was able to afford to conduct his own valuation. Thus, my lord, secondly, we submit that Leibach, the case of Leibach, should not be applied in this case as a principle, as being that this was a materially different situation, being that it goes against the general standard that the defendant should be taken, that the plaintiff should take the defendant as he finds him, including the individual's financial means. This is a generally accepted standard within the law, where known as the eggshell rule, which no matter what the situation is for the defendant, this is a situation that the plaintiff will find the defendant in. It is submitted that the facts of the
But
incident
counsel, my concern is that the reason that your client was in this eggshell position, as you put it, is because your client spent an extra amount of money on this particular house. That money could have been used for his own valuation.
My lord, yes, at first he made a lower offer for the house, but upon seeing the valuation provided to him, which was false, he was forced to make an offer that was greater than the amount he could have used in order to have his own valuation.
He wasn't forced to make the offer, was he? You could have said,
No, my lord.
I'm not willing to do it. I mean, one thing the courts look at a lot is whether there was commercial prudence in a decision not to spend money on something. Do you say it was commercially prudent of him not to get a second valuation?
my lady, in hindsight, it might have been better had he been able, had he had the means to conduct his own valuation. He may have been able to learn of the damages beforehand, but being that he relied on the valuation that was given to him, he did not learn about the damages to the house, which were very significant, until after he had already made the purchases. And under the facts of this instant case, my lady, it is submitted that the facts should be distinguished from previous authorities, being that the claimant's impecuniosity must be taken into account. The foreseeability and the reasonableness tests are adequate to the damages that resulted from the respondent's actions.
So what are we to make from his counsel's, his solicitor's own guidance that he should get a valuation, get his own valuation, particularly for property of this magnitude?
He may have been advised that he should have taken his own valuation, but due to his limited financial means, my lord, he was not under a situation to do so due to his impecuniosity. Furthermore, there's no good public policy reason for the continued application of LIBOR, since it sanctions an unfairness towards poor individuals and individuals who are not capable of mitigating damages. Or why would we have, my lord?
Counsel, is it your position that your client's poor, spending as much money as was spent on this home?
He was not poor, my lord, but he did have limited financial means. And why should an individual not be able to recover for certain damages simply because he is limited in his financial situation? While he did not have an unlimited resource of money to spend, he did invest a great deal into this house, which he had made an initial offer, which was much lower than he was then, which he then made once he relied on the valuation which was provided to him. Under the facts of the instant case, my lord, the appellant who was under a duty to mitigate need not oblige in reducing the damages which he cannot afford to mitigate. Accordingly, since the wrongdoer in this case must take the victim as he finds him, if the position of the latter is aggravated because he is without the financial means of mitigating, the wrongdoer will be responsible for the consequences as well. This is the finding that we find in our original case of Leibosch on page 461. Lastly, my lords, the allegations of contributory negligence fail when the appellant's failure to learn the true conditions of a house or property was due to his own reliance on the respondent's own valuation.
Does that mean if you rely on a valuation that's out there that you never have an obligation to get your own valuation? Where does that end?
Of course, my lord, it would be prudent for an individual to invest in their own valuation if they do have the means to do so. But under certain circumstances, when the seller provides a valuation and one relies on said valuation, this may be a reasonable means to go upon when purchasing a house. But it is conceded that to find one's own valuation would be prudent, yes. Thus, it is submitted that the appellant's reliance on the valuation presented to him defeats the appellant's alleged contributory negligence, and the appellant should be able to recover for the losses resulting from his impecuniosity. In conclusion, for the reasons stated above, it is the submission of the appellant that the decisions of the lower court was incorrect, and accordingly, the appeal ought to be allowed.
Is there a difference from going to impecuniosity between, in this case, where his impecuniosity effectively broke the chain of causation between the negligence and the damage he suffered, and a separate situation where after the damage has been suffered, your impecuniosity prevents you from mitigating the loss that you've already encountered? And I can see perhaps an argument for how impecuniosity shouldn't be taken into account in the second situation. But in this situation where it precedes the loss and is a cause of it, I don't think the same logic applies.
Yes, my lord, if I understand your question, in this case, you stated that the impecuniosity was the cause of the loss, correct?
Exactly. That's,
Yes.
that's what we're saying, isn't it?
Yes.
It's not really a question of mitigation,
Um,
post-breach causation, it's pre-breach.
Yes, my lord, we are arguing that because of the impecuniosity that the appellant found himself in when purchasing this house, he later faced damages once he learned that the house which he had purchased was not truly valued at the amount which he had purchased the house at.
Okay, brilliant.
Thank you.
Bench on the second issues of contributory negligence and impecuniosity. I would first like to clarify the facts, actually. Initially, there was an offer made by the appellant on the house for £400,000. That was before seeing the valuation. Upon seeing the valuation, they made an offer for £480,000. So even without the valuation, they would have been overpaying for the house by $100,000. On the issue of contributory negligence, as my learned senior has already stated, the case of Caparo gives us a three-pronged test for negligence. In this case, proximity is easy to establish because an individual has a duty to themselves. Foreseeability is also easy to establish because the solicitor explicitly advised them to the appellant to get a separate independent valuation on the property. So finally, reasonability, whether it's just, fair, and reasonable to hold them liable, that's the only prong of the test that's at issue here. And this is where impecuniosity comes into play, because as you stated, Your Lordship, the impecuniosity is taken into account when dealing with mitigating damages. So if a harm has already occurred and the victim doesn't have the means to mitigate as well as one would like, that is the burden of the tortfeasor. However, in this case, the damage was caused from the impecuniosity. The impecuniosity is not just an exacerbating factor.
Counsel, Mr. Montoya made the argument that the impecuniosity was caused by your client's valuation, and that it wasn't his own impecuniosity, but rather it was caused by your client's, what I think we'd all agree was a negligent valuation.
Thank you, Your Lordship. I would submit that that is not the case, because if we look at the timeline of events, before the money was paid for the house, the solicitor advised that the appellant received their own valuation, and at that point, before the money was paid, they stated that they didn't have the funds to get a separate valuation. So I would argue that the impecuniosity was in existence before the purchase of the home was occurred. When looking at impecuniosity, we have to look at it objectively, and whether things make commercial good sense. So would it be reasonable for an individual to pay £480,000 for a home, which I believe would, as my learned senior would argued, would be considered a high-end home? Would it be reasonable for an individual to purchase such a home without receiving a separate valuation? I would submit that it is not reasonable to make such a negligent purchase.
Counsel, let me ask you again, where is the line? What separates an expensive home from a home that's inexpensive?
I think it's a value judgment.
Who's to make the value judgment?
I suppose Your Lordships are. So, impecuniosity. So if it's a high-end home, even if it was not a high-end home, at the point that they received the advice from their own solicitor to receive a valuation, it was unreasonable not to. If not for the impecuniosity, a reasonable person would have saw their own valuation at that point. And that is where impecuniosity becomes a separate cause of harm. Because but for the impecuniosity, they would have received their own valuation, and such grievous harm would not have occurred.
Counsel, the difference between paying $400,000 and $480,000 was because of the valuation. Had the increased offer not been made, presumably the appellant would have had the funds. Seems to me the cause of the impecuniosity was the valuation itself.
Thank you, Your Lord. I would argue that if an individual is paying £480,000 or even £400,000 for a home, that it would be prudent to receive a valuation, and that the additional £80,000 shouldn't have been such that they could not afford a valuation. In Lebosque, that the court takes the stance that if the harm is caused by the impecuniosity, then there is no liability for the supposed tortfeasor. So, and I believe that's the case here. I don't believe that the impecuniosity was caused by buying such an expensive home. Additionally, I think that there is a strong public policy argument against allowing homebuyers to negligently purchase homes in reliance on a third-party valuation, assuming that they can sue the third-party valuer if there is a defect in the home. I think that, I submit that allowing such claims would lead to valuers requiring very high insurance, and which cost would be passed on to other home buyers, which would decrease the actual number of valuations received, which would be a harm to public good.
Isn't it a harm to the public good if people are buying properties that in fact are truly worth substantially less than what they're valued at? Aren't we now just passing that loss on to individuals who aren't in a position to procure insurance, for example?
Thank you, Your Lordship. I do agree. However, in this case, the harm would have been very largely mitigated by such a valuation. I'm sorry, one moment, please. Thank you. I would argue, therefore, it's important to make home valuations more available to individuals who would benefit from the services, not make them more expensive and thus less available and less likely to come into play for an individual in purchasing a home. In conclusion, I submit that the appellant has suffered most greatly from their own contributory negligence and from harms flowing from their own impecuniosity and not from the actions of the respondent.
You say contributory negligence. So are you saying that that negligence completely extinguishes any liability that the valuer had, or should it be apportioned in some way between the two of them?
I would argue that at most, my client is liable for the £80,000 difference between the initial offer made by the appellant and the heightened offer that was induced by showing the appellant the the evaluation. However, that's an alternative argument in light of my learned senior's statements earlier.